Hello, good evening everyone. I am Joanna Linmantin, your first reporter for today. And now I will be discussing the Unclaimed Balances Law or the Act 3936 as amended by Presidential Decree 679. So without further ado, let's start. Okay, so what is Unclaimed Balances Law? It is an amending Act number 3936, an act requiring banks, trust corporations, and buildings and loan associations to transfer unclaimed balances held by them to the Treasurer of the Philippines and for other purposes. Okay, so sinasabi dito na ang act daw na ito ay nire-require ang mga bangko, trust corporation, buildings and loans associations na i-transfer ang mga unclaimed balances held by them to the Treasurer of the Philippines and also for other purposes. So, para mas lalo niyong maintindihan, unclaimed balances defined in the meaning shall include credits or deposits of money, bullion, security, or other evidence of indebtedness of any kind, and interest thereon with banks, buildings, and loan associations and trust corporations. Okay, so sino nga ba ang mga tinutukoy na may unclaimed balances? Okay guys, ang mga merong unclaimed balances, ito yung mga taong patay na or yung mga taong hindi na nagdi-deposits or nagwi-withdraw ng pera during the preceding 10 years or more. Another thing is, it is obligatory to every bank to report in the form of sworn statement. Okay, so kanino nga ba sila magre-report? Kay Treasurer of the Philippines, na siya namang mag-i-inform kay Solicitor General that there are such existence of unclaimed balances. Also, take note of this na yung banks, buildings and loan associations, and trust corporations shall refer to institutions defined under Section 2, 39 and 56, respectively of RA number 337, or also known as the General Banking Act, which will be furtherly discussed by the next reporter. Okay, so dumako naman tayo kung ano nga ba yung mga nilalaman ng sworn statement na nabanggit ko kanina. Okay, so sworn statement shall include, number 1 is the names and last known place of residence or post office addresses of the persons in whose favor such unclaimed balances stand. Okay, kailangan daw nakalagay sa sworn statement yung name or yung last known place of residence ng taong merong unclaimed balances. So, number 2 is the amount and the date of the outstanding unclaimed balances and whether the same is in money or in security, and if the latter, the nature of the same. So, kailangan naka-include din doon yung amount kung magkano yung unclaimed balances and the date of the outstanding unclaimed balances. So, number 3 is the date when the person in whose favor the unclaimed balances stands died, if known, or the date when he made his last deposit or withdrawal. So, number 3 is super understandable naman yan, guys. So, number 4 is the interest due on such unclaimed balances, if any, and the amount thereof. So, dapat included din or nakalagay doon sa sworn statement kung meron mang interest due yung unclaimed balances and also the amount kung magkano yung interest na yon. So, these are the posting requirements. So, the above-mentioned sworn statement shall be posted in conspicuous place in the premises of the bank, building, and loan association or trust corporation concerned for at least 60 days from the date of filing thereof. So, dapat daw nakapost yun sa mga visible place under the premise of the bank and loan associations, trust corporations, for at least 60 days from the date of filing. Okay, so dumako naman tayo sa court proceeding steps. So, number 1 step is a notice to the depositor will be given at his last known place of residence or post office address. So, padadalhan daw ng notice si depositor at its last known place or post office address. So, sino nga ba si depositor? Si depositor, siya yung person na may unclaimed balances. So, number 2 is the bank then will report through a sworn statement to the Treasurer of the Philippines that there are such existence of deposits. So, si bank, i-inform niya si Treasurer of the Philippines na merong that there are such existence of unclaimed balances. Paano? Gagawa siya ng report in the form of sworn statement. So, number 3 is the Solicitor General then will proceed to the SCHIT proceedings in court. So, sabi ko nga sa inyo kanina, si Treasurer of the Philippines, siya yung mag-i-inform kay Solicitor General na there are such existence of deposits. So, after nyo ma-inform si Solicitor General, siya yung mag-i-initiate ng SCHIT proceedings in court. So, ano nga ba yung SCHIT? SCHIT, ito yung parang binibigyan mo ng rights yung government to take ownership of the estate assets or the unclaimed property. So, number 4 is a copy of complaint and summons to the president, cashier, or managing officer of each dependent bank, building, and loan association or trust corporation, and by publication of a copy of such summons in a newspaper of general circulations. So, number 4 is bibigyan naman ng kopya ng complaint and summons yung president, cashier, or managing officer of each dependent institutions. And also, ipapublish din sa newspaper of general circulation yung kopya ng summons. So, number 5 is, ito na, after hearing both sides of all parties na nag-appear dun sa proceedings, kapag na-determine naman ni court na that balances are unclaimed, so, the court will render its judgment declaring that such balances is cheated in favor of the government of the Philippines. So, number 6 is such unclaimed balances, together with the increase in proceeds thereof, shall be deposited with the Treasurer of the Philippines to the credit of the government, to the Republic, Government of the Republic Act of the Philippines to be used as Congress may direct. Okay, that's all. I hope may natutunan kayo, guys. Thank you for listening. And the next topic will be the banking laws, which will be discussed by Jo Marie Hanner and Kathleen Olaybar.
Good day everyone, I'm Jo Marie Hanner, ang first reporter ng General Banking Law. Banking institutions are governed by the following laws. A. General Banking Laws. Under General Banking Laws, meron tayong dalawa. General Banking Law or RA 8791 and New Central Bank Act or RA number 7653. B. Special Banking Laws. Meron tayong tatlo. Una, New Rural Banks Act or RA number 7353. Next is Private Development Bank Act or RA number 4093. Savings and Loan Association Act or RA number 3779. And Thrift Bank Act RA number 7906. Letter C. Other laws affecting banks. Una, secrecy of banks deposit law RA 1405, unclaimed balances law or Act number 3936, and Philippine Deposit Insurance Corporation Act RA number 3591. So meron tayong 5 primarily interested in the business of banking. Una, government. Pangalawa, depositors. Pangatlo, investors. And pang-apat, creditors. And pang-5 ay borrowers. General Banking Law, RA 8791. Kailan nga ba ito naisabatas? Naisabatas ito noong May 23, 2000. Banks. So ano nga ba ang banks? Banks shall refer to entities engaged in the lending of funds obtained in the form of deposits. Ang bank ay isang entity na naglelend ng pera sa mga borrower. So saan nga ba nanggagaling yung funds? Nakukuha nila ito sa mga deposits ng mga depositors, generally make money by borrowing money from depositors and compensating them with a certain interest rate. The banks will lend the money out to borrowers, charging the borrowers a higher interest rate and profiting off the interest rate spread. Banks are entities duly authorized by the Monetary Board to engage in the business of regularly lending funds obtained regularly from the public through the receipts of deposits or any kind. Quasi-banks. These are institutions which offers bank-like services, asset management and loans, but which does not have a banking license and is thus not accountable to the supervisory authorities. Quasi-banking activities means borrowing from 20 or more personal or corporate lenders, yun nga, through issuance, endorsement, or certificate of assignment. Walang bangko ang pwedeng magkaroon ng quasi-banking function nang walang authorization from Bangko Sentral. Ang Bangko Sentral ang governing body na nag-govern sa mga banks. Organization and operation. A. Authority to register incorporate. The SEC shall not register the articles of incorporation of any bank or any amendment thereto unless accompanied by certificate of authority issued by the Monetary Board and under its seal. The certificate of authority shall not be issued unless the Monetary Board is satisfied. Una, that all requirements of existing law and regulations to engage in the business of for which the applicant is proposed to be incorporated have been complied with. Nasa section 14.1. Number 2, that the public interest and economic conditions, both general and local, justify the authorization na mababasa sa section 14.2. And the last one is that the amount of the capital that financing organization and direction and administration as well as the integrity and responsibility of the organizers and administrators reasonably assure the safety of deposits and public interest. So, ano nga ba yung mga requirements? Under Section 8 ng General Banking Law, meron tayong tatlo. Ang una natin ay, the entity is a stock corporation. So, dapat ang entity natin ay stock corporation. Malawa, its funds are obtained from the public, 20 or more persons. So, yun nga, di ba alam naman natin na ang banking ay nagmumula ang funds sa public or sa ating mga clients. And then pangatlo, the minimum capital requirements prescribed by the Monetary Board are satisfied. So under Section 6 ng General Banking Law, a person or entity cannot engage in banking or quasi-banking functions without a certificate of authority from BSP. Hindi pwedeng mag-engage ang isang entity na sa banking or quasi-banking function kapag wala itong permiso mula sa Bangko Sentral. Classification of banks under Section 3. Una, universal banks. Ang universal banks primarily pinagsama-sama ang tatlong service ng banking, ang wholesale banking, ang retail banking, at investment banking. Ang wholesale banks, dito yung mga malalaking client tulad ng ibang mga bangko, government agencies, large corporations, at etc. Kabaliktaran naman nito ang retail bank, na primarily nakafocus sa mga individual persons or small businesses lamang. Ang investment banking naman, ang primary function is to help individuals or organizations to raise their capital and provide financial consultations to them. Commercial banks. So, ang commercial banking naman is where most individual or small businesses do banking. Tulad ng savings account, loans, checking accounts, deposits, and etc. Pangatlo is thrift banks. Ito namang thrift banks is specializes on savings and loaning. So, ano nga ba pinagkaiba nito sa commercial banks? Thrift banks offer higher yields on savings account and provide limited lending services. So, yun nga, mas malaki yung may bibigay nitong interest sa mga customers nito kaysa sa commercial banks. So, ang last naman natin ay rural banks and cooperative banks. So, ang rural and cooperative banks ay mas kilala sa mga rural or provincial places. Their role is to promote and expand the rural economy in an orderly and effective manner by providing basic financial services. So, nakafocus ito sa kadalasan sa mga agribusinesses tulad ng pagsasaka and etc. So, ito na nga sa last ng report ko is functions of banking. So, meron tayong dalawang basic function. Yung una is loan function o yung paglilend ng pera sa borrowers. And yung pangalawa naman is deposit function o yung pagde-deposit ng mga clients nito sa bangko para magkaroon nito ng funds. So, meron nga tayong other functions na meron ang universal banks and commercial banks. Ang una is receive in custody funds, documents, and valuable objects. Pangalawa, an act as financial agent and buy and sell by order of and for the account of their customer shares, evidence of indebtedness, and types of securities. Pangatlo, make collection and payments for the account of others and perform such other services for their customer as are not incompatible with banking businesses. Pang-apat naman is upon prior approval of the monetary board, act as a managing agent, advisor, consultant, or administrator of investment management, advisory, consultancy accounts, and the last one, rent out safety deposit boxes.
So hello everyone, my name is Kathleen Olivar and this is the other part po of General Banking Law already introduced by Jamari Hanier. So again, si bank po ay engaged in lending of funds. Lending of funds po in a way na nilelend nila yung sarili mo ring pera na itinabi mo sa account mo sa bank po nila. Then there is conditions po for organization. The Monetary Board may authorize the organization of a bank or quasi-bank subject to the following conditions. Number 1 condition po is that the entity is a stock corporation. Stock corporation po are for-profit organization and they issue shares of stock that each stock represent a partial ownership with grant of certain rights. Number 2 condition po is that its funds are obtained from the public, which shall mean 20 or more persons. And the number 3 condition po is that the minimum capital requirements prescribed by the Monetary Board for each category of banks are satisfied under Section 8 po of General Banking Law. Then there is prohibited acts or transactions po. Number 1 po is the bank officials or employees are prohibited to disclose to any unauthorized person any information related to the funds or properties in the custody of the bank belonging to private individuals, corporations, or any other entity, unless there is an order of a competent court of competent jurisdiction. So, ang pinupunto po ng number 1 is about confidentiality po. It is a common sense naman po siguro, especially information related to money na to remain confidential unless there is a legal authorization po to share or disclose the said or specific information po in the custody of the bank. Number 2 po is banks are prohibited from outsourcing inherent bank functions. Outsourcing means finding other person outside the bank to do some specific task. So the information held in the custody of the bank must remain secured between the client and the bank personnel only. Number 3 is no bank shall employ casual or non-regular personnel or too lengthy probationary personnel in the conduct of its business involving bank deposits. So, probationary personnel means an employee on trial. Kumbaga, the employer will still determine whether qualified or not. So, the employee must be a regular personnel. For the purpose rin po kung sino mag-held responsible if something happen po, syempre involved yung pera and it's super big deal and sensitive. So now, we're going to know po the deposit function of bank. So, fixed savings and current deposits of money in banks and similar institutions shall be covered by the provisions concerning simple loan under Article 1980 Civil Code of the Philippines. Now, moving on po about foreign stock holdings. So, foreign individuals and non-bank corporations may own or control up to 40% of the voting stock of a domestic bank. This rule shall apply to Filipinos and domestic non-bank corporations under Section 11 po of General Banking Law. And there is grandfather rule po, and it is the percentage of foreign-owned voting stocks in the bank shall be determined by the citizenship of the individual stockholders in that bank. The citizenship of the corporation, which is a stockholder in the bank, shall follow the citizenship of the controlling stockholders of the corporation, irrespective of the place of incorporation, under Section 11 of General Banking Law. So, based on my understanding po, so to determine po kung sino makaklasify as foreign stockholders is kung sino yung majority, regardless of the place of incorporation po. The next one po natin is prohibition on public officials. So, no appointive or elective public official, whether full-time or part-time, shall at the same time serve as officer of any private bank under Section 19 of General Banking Law. So, but there is exceptions po. Number 1 exception po is when the service of the public official is incident to financial assistance provided by the government or a government-owned or controlled corporation to the bank. Number 2 exception po is when the law provides otherwise. Example po is rural banks allow public officials, elective or appointive, to serve in a rural bank in any capacity under Section 5 po of Rural Banks Acts and under Section 19 po of General Banking Law. Also, there is fit and proper rule po in the bank management. So, to maintain the quality of bank management and afford better protection to the depositors and the public in general, the Monetary Board shall prescribe, pass upon, and review the qualifications and disqualifications of individuals, elected or appointed bank directors or officers, and disqualify those found unfit under Section 16 of General Banking Law. So now moving on po about foreign banks mode of entry. So number 1 po is by acquiring or owning up to 60% of the voting stocks of an existing bank. Number 2 is by investing in up to 60% of the voting stock of a new local banking subsidiary, or by establishing branches with full banking authority under Section 2 of Foreign Banks Liberalization Act. To note about the acquisition of voting stocks in a domestic bank, the Monetary Board may authorize a foreign bank to acquire up to 100% of the voting stock of only one bank organized under the Philippines law. However, this is allowed only within 7 years from the effectivity of General Banking Law, which is on June 13 of 2000. So, until 2007 lang po. So, further, at all times, the control of 70% of the resources or assets of the entire banking system is held by banks, which are at least majority owned by Filipinos under Section 3 or 73 rather of General Banking Law. So now, there is a revocation of license of a foreign bank. So, the Monetary Board may revoke the license to transact business in the Philippines of any foreign bank under the following instances. Number 1 is when the foreign bank is insolvent or in imminent danger thereof, or that its continuance in business will involve probable loss to those transacting business with it under Section 78 of General Banking Law. Now to the last part po of General Banking Laws. There is a supervision po and examination po of banks. So, the operations and activities of banks shall be subject to supervision of the Bangko Sentral ng Pilipinas. It shall also have supervision over the operations of and exercise regulatory powers over quasi-banks, trust entities, and other financial institutions which under special rules are subject to Bangko Sentral supervision under Section 4 of General Banking Law. And there is primary responsibility po of BSP or Bangko Sentral ng Pilipinas, and it shall provide policy direction in the areas of money, banking, and credit under Section 5 of General Banking Law. And the last one po is, it shall provide policy directions in the areas of money, banking, and credit. It shall have supervision over the operations of banks and exercise such regulatory powers over the operations of finance companies and non-bank financial institutions performing quasi-banking functions and institutions performing similar functions under Section 3 of NCBA. And that's all po for General Banking Laws. Thank you for listening.
Hello everyone, this is Rosary Amplis and let us talk about loans. So, meron tayong classification and types of loans. Sa classification of loans, meron tayong 4. Ito ay ang secured, unsecured, open-ended, and closed-ended. Sa secured loans, meron tayong isinisecure na assets such as property, car, or yung mga bahay na pwede nating ipang-secure dun sa loan na kinuha natin. And if ever man na hindi tayo makabayad dun sa loan, is magpo-proceed si creditor sa pagkuha ng asset na ipinang-secure natin or para ibenta niya yun as an exchange dun sa inutang natin. Next is unsecured. Sa unsecured loans, wala tayong security or wala tayong binibigay na asset as a security doon sa creditor. Bale, ang mangyayari lang dito is mas mataas yung interest rates na ibibigay sa atin ni creditor and mas maraming requirements ang hihingi niya sa atin para ma-avail natin itong loan na ito. Next is the open-ended loans. Ang open-ended loans, ito yung pwede mong ulit-ulitin ng paghiram. Example ito is yung credit card. So, after mo makapag-swipe ng iyong card and makapag-loan or makahiram dun sa iyong credit card, pwede ka pa rin makahiram dun sa credit card as long as pasok pa dun sa iyong credit limit or di kaya nabayaran mo na iyon. Next is the closed-ended. Ito yung mga loans na once na tapos mo na yung loan na yun, nakahiram ka na nun, and nabayaran mo na, kailangan mo umulit sa umpisa, magpasa ng requirements, and magpa-approve bago mo ma-avail ulit yung loan na yun. Punta naman tayo sa types of loans. So, napakaraming klase ng loans. Pero, naglista lang ako ng iilan dito na pwedeng or pinaka-common sa atin. Unang-una na dyan yung home loan. So, para saan ba ang home loan? Syempre, para sa home. Kasi, ang home loan na ito, ang main purpose nito ay makabili ka ng bahay, condominium, townhouse, o di kaya residential lot, and pwedeng pagpapakonstruct or renovation ng bahay mo. Next naman is property loan. Other than home or vehicle, there are other properties na pwede mong bilhin and you can loan for it. And then next naman is yung vehicle. Pwede ka rin makapag-loan para makabili ka ng sasakyan. So, either brand new or used yan, pwedeng ipasok mo sa loan. Next naman is education loan. Kung kunyari gusto mo makapag-aral pero wala kang enough cash as of now, pwede kang makapag-loan to continue your education. Next is gold loan. Naglo-loan ka to buy gold kasi merong mga traders ng gold. So, pwede nilang gawin to finance it is makapag-loan sila. Next naman is business loan. So, kung gusto mo mag-start ng business and you don't have enough money para mag-start, you can avail a loan and habang ongoing yung business mo, unti-unti mo yung babayaran. Next naman is consolidated loan. So, kapag pinagsama-sama mo yung iba't ibang klase ng loan, pwedeng maging consolidated loan yun and subject, syempre, sa terms. So, next naman is payday. Ito yung pwedeng i-advance mo yung salary mo and bale, yun na yung ilo-loan mo, yung mismo sahod mo in the future. And next naman is yung loan policy. Itong loan policy na ito is yung nag-avail ka ng loan and yung collateral mo or yung ipang-secure mo is yung insurance policy mo. Next naman is loan construction. So, kung may gusto kang ipagawa na ipa-construct either a building or pwede ring bahay mo, pwede ka ring mag-avail ng loan construction loan or loan construction. Next naman is ang equipment loan. So, if you are in the industry na kailangan talaga ng mga heavy equipments or any kind of equipments, pwede kang mag-avail ng equipment loan. And next is yung term loan. Yung term loan na ito, parang ang ano lang nito is, meron tayong mga short term and then long term loans. So, dito yan nagpo-fall under. And lastly is yung personal loan. Ito yung personal loan na usually cash lang ito. So, wala ka talagang pinaka nakalagay dun sa term kung para saan ito. So, may paggagamitan ka for your personal use. So, hindi po ako nagpo-promote ng loan, pero that's all for my...
We interrupt this program for an important news announcement.
Dumako naman po tayo sa kasong kinasasangkutan ni dating Foreign Affairs Secretary Perfecto Yasay na inaresto kahapon dahil sa umano'y paglabag niya sa General Banking Law at New Central Bank Act. Para maintindihan natin ang mga banking law na yan sa ating bansa, kausapin natin ang ating kapuso sa batas, Attorney Gabby Concepcion. Attorney Gabby, pakipaliwanag naman po ito.
Well, actually, no, itong dalawang batas na to na minimension nila, they go hand in hand. Yung Central Bank Act ang siyang naglalahad ng lahat ng mga kapangyarihan ng Bangko Sentral at ng Monetary Board over all banks. Habang yung isa naman, yung RA 8791 o ang General Banking Act, siya naman ang batas ukol sa pag-operate ng mga bangko. So nakalagay dito kung ano ang mga pwede at mga hindi pwedeng gawin ng mga bangko. So intertwined itong dalawang to dahil yung penalties para sa mga requirement sa ilalim ng banking law, yung pagpataw ng penalty na napapasaloob sa ilalim ng Central Bank Act naman.
Ano-ano naman po yung mga bawal gawin ng mga bangko o officer ng mga bangko tulad nga ng kaso ni dating Secretary Yasay?
Well, of course, no, gusto nating sabihin na hindi pa natin nababasa pa talaga ang complaint at kung ano ang kaso laban sa kanya. Pero base sa mga report, merong halimbawa ng mga aligasyon ukol sa hindi pag-file ng mga kinakailangang mga report at financial statement para matunton ang actual financial condition ng Bangko Filipino noon. May anomalyang pagbigay ng loan sa isang kumpanya na ang may-ari din, di umano, ay mga may-ari din ng Bangko Filipino. So sa ilalim ng General Banking Act, ito siguro yung rule ukol sa DOSRI o ang pagbibigay ng benepisyo sa mga direktor, officer, stockholder or related interest na isang bangko dahil nga baka naman maubos ang pera ng bangko sa pagbigay ng utang sa mga may-ari, mga stockholder or director nito, lalo na nga kung nasa financial distress na ang isang bangko. So kasama na rin dito ang requirement na dapat ipagbigay alam sa BSP kung naibigay na ang ganitong klaseng utang. So, base sa warrant of arrest, mukhang ito nga raw ang naging main problem kaya siya naaresto.
Attorney, bakit naman po stricto yung pagpapautang ng pera sa mga direktor at stockholder o yung tinawag nyo na DOSRI? Kailangan ba silang mangutang pa sa ibang bangko?
Well, hindi naman totally bawal. Kailangan lang na above board at hindi sobra dahil nga baka maapektuhan ng mga depositor ng bangko kung mauubos ang kaban ng bangko at lalo na nga kung in financial distress ito. So ito ay matuturing na unsafe or unsound banking practice. Kaya mahigpit ang BSP dahil may iwang nakanganga ang mga inosente mga depositor natin kung sakaling magsasara ang bangko dahil hindi niya na kayang tustusan, bayaran at ibalik pa ang pera ng mga depositor nito. So kahit covered ng PDIC, yung Insurance Corporation for deposits, hindi pa rin sapat to kung of course dito nakatago ang life savings ng isang tao.
So tama ba at naayon ba sa batas ang pagkakaarestong ginawa kay dating Secretary Yasay? Kasi may sinasabi po siya na 2009 siya pumasok, 2003 to 2006 if I remember correctly yung sinasabing kaso.
Well, yun na nga, no? But of course, in the first place, ito ay ayon sa isang warrant of arrest issued by a judge from a court in Manila. At mag-i-issue lamang to ng warrant of arrest kung matapos niyang tingnan ang lahat ng ebidensya ng prosecution at makikita niyang meron talagang probable cause laban dun sa akusado. Of course, tulad nga ng sinabi mo, ay sinasabi na ni Yasay na nangyari ito bago pa siya naging direktor ng Bangko Filipino noong 2009. Of course, kailangan din natin bigyan ng weight yung naging hatol ng judge na meron talagang ebidensya laban sa kanya. So makikita natin na ito ang magiging main defense niya. So siguro abangan na lang natin ang susunod na kabanata.
Alright, maraming salamat po Attorney Gabby for enlightening us this morning.
Maraming salamat.
Hi, I am Mary Joy Tejerero and I will talk about the first part of the Anti-Money Laundering Act of the Philippines. Anti-Money Laundering Act of the Philippines. To start, ito pong batas na ito ay marami ng naging amendments. Yung kauna-unahan na itong Republic Act 9160 na isinabatas noong July 23, 2001. Sumunod dyan na itong RA 9194, tapos RA 10167, also known as the Terrorism Financing Prevention and Suppression Act of 2012. Tapos itong 10365, known as an act to further strengthen the anti-money laundering law. And lastly, at ito yung pinaka-recent, tapos hanggang dyan yung kailangan natin itakal is yung 10927 na ipinasa lang noong July 25, 2016. For now, ano nga ba yung stated policies or purpose kung bakit na isabatas itong AMLA? According to Section 2, there are 3 purposes. Yung number 1 is for the confidentiality and integrity of bank accounts. Align dito sa bank secrecy law natin na confidential pa rin ang laman ng bank accounts mo. Pero with regards dito sa integrity, sabi ng batas, ang poprotektahan lang daw nila ay yung mga legitimate accounts. Meaning yung galing lang sa lawful activities, galing sa mabuting paraan. Second is Philippines should not be a money laundering site for the proceeds of unlawful activities. Ibig sabihin lang, Itong batas na ito, pine-prevent niya na maging tourist spot or tourist destination tayo ng mga kriminal sa ibang bansa. Para hindi nila dito dalhin sa atin yung mga perang galing sa masamang gawain. Kasi 'di ba dati walang batas para hulihin sila. Pangatlo is itong to cooperate in transnational investigation and prosecution. Ang money laundering kasi, mahirap daw yan hulihin. Sa isang bansa pa lang mahirap na hulihin. Paano kung maraming bansa pa yung involved? Sa sobrang dali ng mag-transfer ng pera ngayon, isang click mo lang sa phone mo na sa ibang bansa na yung pera mo. Kaya nagkaroon ng cooperation ng mga bansa para somehow matigil itong masamang gawain. So, going to Section 4, Money Laundering Offense, let's define first yung money laundering. Sabi dito, money laundering is a crime whereby the proceeds of an unlawful activity are transacted, thereby making them appear to have originated from legitimate sources. Ibig sabihin lang yan, yung pera na galing sa masama, ginagawan nila ng paraan na magmukha siyang malinis. Papalabasin nila ng malinis yung perang yon. And it is committed by the following. Etong A is about yung paglaunder mo talaga ng pera. Yung may knowledge ka na yung katransak mo ay galing sa unlawful yung pera niya, tapos ipapasok nila sa legitimate financial business, subsequently ilalabas din. Pagkalabas ng pera, syempre it will look na originated siya from legitimate sources. Ito namang B, you simply tolerated na nakipagtransa ka man or hindi, pero you facilitates the offense of money laundering na na-refer sa paragraph A kasi you tolerate. Itong C, any person knowing that any monetary instrument or property is required under this act to be disclosed and filed with the Anti-Money Laundering Council but fails to do so. Ibig sabihin, kahit hindi mo sure kung galing ba sa unlawful yung pera na ng katransak mo, pero na-meet niya yung standards na required or reportable transaction siya na kailangan mo siyang i-disclose at i-file sa Anti-Money Laundering Council pero hindi mo nagawa. Isa din yun sa pag-commit ng money laundering offense. Next is unlawful activities. Kanina pa natin binabanggit itong unlawful activities na yung pera na galing sa unlawful activities ay i-convert para magmukhang malinis or galing sa lawful activities. Pero ano nga ba yung mga unlawful activities or predicted crimes of money laundering? Halimbawa dyan ay kidnapping for ransom, drug trafficking, graft and corruption, plunder, robbery and extortion, qualified theft, swindling stapa, corruption of public officers, violation of Electric Commerce Act, carnapping, at marami pang iba na hindi na natin babanggitin kasi masyadong magko-consume ng oras. Sa paghanap ko ng example, siguro classic example dito is yung nangyari nung 2016. Ika nga nila is one of the world's biggest cyber money heist. Kasi yung Bangladesh, nawalan sila ng $81 million and alam na kung saan nawala. Syempre, dito sa Pilipinas. Yan yung RCBC Bank. Noong 2016, may mga hackers na nag-wire ng 81 million galing sa Bangladesh Bank foreign reserve account. Tapos, gumawa sila ng 4 na fake account sa RCBC branch na headed ng bank manager na sa research ko, nagkaroon siya ng kaso. Tapos, winidraw nila yon, kinonvert sa peso, nilaunder nila sa local casinos. And, siguro yun yung nag-trigger kung bakit. Dati kasi hindi kasama yung casino sa mga kailangan mag-report or reportable covered institutions yan. Ngayon, kasama na sila sa kailangan mag-report. Very controversial itong issue na to kasi sabi ng bank managers, yung mga boss niya, yung president ng RCBC, alam na yun yung nag-utos daw sa kanya at alam na ginagawa niya yun. Pero going back, research nyo na lang, maganda siya basahin. Dito na tayo sa stages of money laundering. Meron daw 3 stages. Placement, layering, and integration. Simply yung placement, ito yung pera na galing sa unlawful activities ay i-introduce sa financial system ng bank. Second, layering, ito yung series or combination of transaction designed to erase the trace of unlawful activities. Dito na nangyayari yung magic. So, siguro na itong 81 million, yung layering is yung nilolaunder na nila sa local casinos. Kinonvert nila sa peso, nilaunder sa local casinos, wala na. Hindi mo na ma-trace back kung nasa na. Integration, ito naman yung magagamit na nila yung pera as if galing siya sa legitimate sources. Mas complex pa daw itong stages of money laundering sa totoong buhay. Ito lang yung binigay sa mga research ko, ganyan. And sana hindi na raw matutunan kung paano mag-money launder. Isa pang halimbawa ng unlawful activities, kung napanood niyo yung The Accountant noong 2016 din. Si Ben Affleck doon, auditor siya or accountant siya ng isang laundry shop. Labada, laundry shop. Pero magtataka ka, never nagkaroon ng labada sa laundry shop na yon. Walang nilabhan kahit isa dun sa laundry shop na yun. Pero kompleto yung papeles nila. Nagbabayad sila ng buwis sa tamang oras. Ganyan. Pero, yun nga, walang labada. Yun pala, cover lang yung laundry shop na yon. Pero ang ginagawa nila is yung mga kriminal pumupunta sa kanila, tapos itong si Ben Affleck, siya yung magko-convert ng mga pera na yon para magmukha siyang malinis. Siya yung naglo-launder ng pera. Yung iba ginagawang ini-invest sa laundry shop, tapos ilalabas ng laundry shop. Paglabas ng laundry shop, mukha na siyang galing sa legitimate sources kasi legit source yung laundry shop, 'di ba? So ayun, maganda rin siya panoorin. Next, sabi, ang meron lang daw sa batas natin ay preventive measures. Tinatry natin hulihin habang nangyayari pa lang yung money laundering. So, sa preventive measures, merong 3. Transaction reporting, record keeping, and customer due diligence. Under transaction reporting, meron ulit 3. Ito yung mga kailangan i-report or reportable sila. 1 is covered transaction, 2 realty transactions, and 3 is suspicious transactions. Dito sa 1 and 2, ang importante lang dito is yung amounts eh. Sa 1, merong 3. In excess of 500,000 pesos within 1 banking days. So, para sa bank, in excess of 500,000 pesos, reportable. Para sa casino, in excess of 5 million, reportable. Para naman sa jewelry dealers, in excess of 1 million, reportable. For single transaction yan ha. Sa realty transaction naman, ito yung about sa lupa, pagbebenta ng lupa. Ang amount naman dito is 500,000 pesos, in excess of 500,000 pesos, and reportable siya within 15 days from the date of registration of the transaction. So, ayan yung para sa covered transactions and realty transactions. Next is suspicious transactions. So, sabi dito sa suspicious transaction, regardless of the amount involved, where any of the following circumstances exist. Meaning, wala tayong pakialam dito sa amount. Katulad dun sa kaninang covered transactions and realty transactions na may mga amount, basis, ceiling ng reportable. Dito, wala tayong pakialam sa amount eh. Ang rational natin dito is what makes the transaction suspicious. Kapag na-meet niya itong isa man lang dito sa 7. So, sabi sa 1, there is no underlying legal or trade obligation, purpose, or economic justification. Number 2, the client is not properly identified. Number 3, the amount involved is not commensurate with the business or financial capacity of the client. Number 4, taking into account all known circumstances, it may be perceived that the client's transaction is structured in order to avoid being the subject of the reporting requirements under this act. So, halimbawa, there is a balut vendor and nagde-deposit siya ng 400,000 So, hindi siya umabot dun sa covered transaction, 'di ba? Kasi 500,000 yun eh, yung ceiling dun. Pero, reportable ba siya? Oo, kasi under suspicious transaction, yung kapag yung amount involved is not commensurate with the business or financial capacity of the client, suspicious transaction siya and reportable siya. Kasi yung customer profile, taliwas siya doon sa perang hawak ng client mo na yun eh. So, under suspicious transaction, reportable siya. Number 5, any circumstances relating to the transaction which is observed to deviate from the profile of the client and or the client's past transaction with the covered institutions. Halimbawa dito sa 4 and 5 is, etong si balot vendor, hinati niya. Iniiwasan niya na, alam niya na mare-report siya kapag nag-deposit siya in excess of 500,000 within one banking day. Diba sabi sa batas, one banking day. Kaya ang ginawa niya, every day, 5 days, naghuhulog siya ng 100,000. Reportable ba siya o hindi? Sabi lang kasi sa batas, one banking day. Pero under suspicious transaction, reportable pa rin siya. Kasi, mapaperceive natin na yung client's transaction, naka-structured siya para ma-avoid yung magiging subject ng reporting requirements. Hindi man naabot yung ceiling, pero bakit inaaraw-araw niya pa, 'di ba? Nagde-deviate siya ng, tapos yung customer's profile niya pa, ganito, ganyan. Not being judgmental, pero yun yung sabi sa batas eh. Kailangan yung customer profile mag-commensurate siya dun sa business or financial capacity, dun sa amount na ini-involve ng client na yun. 6 and 7, the transaction is in a way related to an unlawful activity or offense under this act that is about to be is being or has been committed. 7, any transaction that is similar or analogous to any of the foregoing. Sabihin lang ng 6 and 7, any other na hindi nabanggit pero similar doon sa nasabi sa taas is reportable under suspicious transactions. Covered entities. So, sino ba yung mga nagre-report ng mga transaction reporting na nabanggit natin kanina? Yung covered transactions, realty transactions, and suspicious transactions. Sino yung nagre-report? Sabi ng batas, meron 3. Una, financial institution regulated or supervised by SEC, Insurance Commission, and BSP. So, madaling salita, hindi si SEC, hindi si Insurance Commission, and hindi si BSP ang nagre-report. Ang nagre-report ay yung mga financial institution regulated or supervised by them. Sa BSP, ito yung mga bank, pawn shop, foreign exchange, yan, mga remittance, ganyan. Sa Insurance Commission naman, ito yung mga insurance company, insurance holding company. Sa SEC is may listahan lang to. And classic example is dealers, brokers, ganyan. Designated non-financial business and profession, ito naman is yung hindi siya under ng SEC, Insurance Commission, and BSP, pero sabi ng batas, mag-report pa rin daw sila. Sila yung mga jewelry dealers, dealers of precious metals, and company service providers, at saka casino. Etong casino, katulad nga ng sabi natin dati, or kanina, wala to dati sa batas, sa AMLA. Pero dahil dun sa nangyari nung 2016 na nag-trigger ng bagong amendments, ayan, nagkaroon na ng amendments at kasama na tong casino sa covered entities. Next is Land Registry Authority or Registry of Deeds. Ito about lang to sa realty transactions, yung sa condo, lupa, pagbebenta ng bahay, ganyan, lupa, na in excess of 500,000, reportable. Meron ditong take note na lawyers and accountants acting as independent legal professional are not covered with respect to privileged information covered by confidentiality and attorney-client relationship. Ibig sabihin lang na, natakal na rin natin to dati sa ating auditing theory na meron tayong confidentiality. So, yung information na na-acquire natin during the course of performing professional services should not be used or disclosed any of such information without proper or specific authority, or unless there is a legal or professional right or duty to disclose. Unless there is, saka lang natin siya i-disclose. So, ang tanong ngayon is, paano kung etong tatlong to, nag-report sila, tapos may nireport sila na na-acquit, pero napatunayan na wala naman palang sala or hindi money laundering. Pwede bang kasuhan pabalik yung mga nag-report? Sabi sa batas, hindi raw. Kasi pag nagawa naman sa report, yung reporting in good faith and under obligation of the law shall not be administratively, criminally, or civil liable kasi ginawa lang naman ng reportable or ng covered entities yung sinabi ng batas na dapat nilang gawin at i-report. And ang tawag daw doon is safe harbor provision. That's all for my report. Thank you.
Good evening everyone, my name is Shane Ermoger at last reporter na kaya kapit lang malapit na matapos. These are the obligations of covered institutions. Number 1, covered institutions shall establish and record true identity of clients based on official documents. Basically, ito yung know your customer. Hindi lang basta kinikilala sa pangalan but tinitignan mo din yung pattern ng customer mo. Kung paano siya kumita, paano siya gumagastos, ano ba negosyo niya, ganon. Pangalawa, record keeping. Lahat ng sinasubmit sa'yo, lahat ng transactions, all records, you don't dispose it right away. It shall be maintained and stored for 5 years. Pangatlo, kung ang transaction ay parehas na covered and suspicious, i-record mo na lang siya as suspicious transactions. Next, it shall not be considered a violation of bank secrecy laws. It's a matter of confidentiality. Bawal mo ipagkalat or ipagsabi kung kani-kanino na merong covered or suspicious report na naganap. Pinaka-last ay yung tinatawag na safe harbor provision. For example, ako, kinasuhan ako money laundering, pero napatunayan na wala naman talaga akong kasalanan. Pwede ko ba sila idemanda? As long as the report was done in good faith, the reporting entity has no liability since ginawa lang naman nila yung trabaho nila. Therefore, hindi pwede. Okay? And meron tayong tinatawag dito na reportorial requirements. Kailangan within 5 working days from occurrence ng covered or suspicious transactions, dapat ma-report mo agad yun sa AMLC. What is AMLC? So, meron tayong tinatawag na Anti-Money Laundering Council. This is the agency of the government of the Philippines that is tasked to implement the provisions of Anti-Money Laundering Act. This is composed of, number 1, the Governor of the Bangko Sentral ng Pilipinas as a chairman, the Commissioner of the Insurance Commission, and the Chairman of the Securities and Exchange Commission as members. They have to act unanimously. Ano man ang decision nila, dapat unanimous sila. Yes lahat or no lahat, ganon. The AMLC or the Anti-Money Laundering Council has 12 functions or powers. Ito yon. Number 1, to require, issue, institute, cause the filing, investigate transactions, apply for the freezing, implement, ayan. But I won't elaborate it one by one since kayang-kaya nyo naman intindihin yan. I-highlight ko lang yung 4 na powers that will summarize the whole. First one, AMLC has the function to file for criminal cases. Remember, money laundering is a crime. Therefore, AMLC itself, sila yung complainant. So, saan sila magpa-file? It's either sa Department of Justice, kung ordinary people naman yung kakasuhan, or sa Ombudsman kung government official. Depende sa type ng tao na dinedemanda nila. Pangalawa, meron tayong tinatawag na forfeiture. It is the loss or giving up of something as a penalty for wrongdoing. Ito yung mga lahat ng proceeds of illegal activities, kung kunwari, na-convert mo na siya into monetary instrument or ibinili mo na siya ng property, lahat yun babawiin yun ng gobyerno basta galing siya sa illegal activities. Bakit? Kasi nga, illegally obtained yun, galing nga yun sa masamang pamamaraan, di ba? Ayaw nga natin sa mga masasama. Pangatlo is the power of bank inquiry at pang-apat yung freeze order. Power of bank inquiry, dito tinitignan ng AMLC yung bank deposit or investment ng certain people na yon. While freeze order naman, basically, you stop the movement of monetary instrument or property which in any way is related to unlawful act. Ang issue dito is itong dalawang to, they both interfere with private rights, di ba? So as a general rule, yung AMLC, kukuha muna sila ng court order bago sila mag-perform ng bank inquiry and freeze order. So anong basis nitong court order na to? Syempre hindi naman pwedeng basta-basta na lang sila kukuha, di ba? If there is a probable cause that the deposits are related to money laundering or unlawful activities, go. While sa freeze order naman, if there is a probable cause that the monetary instrument or properties are related to unlawful activities. But there is always an exception to the rule. Dito, pwede nang i-perform ni AMLC itong dalawa na to even without court order. Tuwing kailan? Di ba meron tayong unlawful activities? Super dami yan, mga 34 yan nasa listahan. Sa bank inquiry, kung ang probable cause ay kidnapping for ransom, Comprehensive Dangerous Drugs Act, hijacking and other violations, Anti-Terrorism Act of 2020, and Terrorist Financing Prevention and Suppression Act, hindi na kailangan ni AMLC ng manghingi pa ng court order. For freeze order naman, kung ang probable cause ay Anti-Terrorism Act of 2020 at Terrorist Financing Prevention and Suppression Act.